There is a moment that happens in the life of almost every serious preparedness-minded person where the activity that began as a rational response to documented supply chain fragility, to the well-established vulnerability of modern food distribution systems, to the statistically certain recurrence of natural disasters and infrastructure failures, suddenly feels legally precarious. It happens when they read a headline about emergency powers legislation. It happens when they hear a second-hand account of a neighbor being questioned about the number of fuel cans in their garage. It happens when they encounter one of the dozens of viral social media posts that circulate with increasing frequency, claiming that some new regulation, some executive order, some obscure provision buried in emergency management law has made the thing they are doing, storing food, water, fuel, and medical supplies in quantities sufficient to sustain their household through an extended disruption, into a criminal act. And the response to that moment of legal anxiety is almost universally one of two things, both of which are problematic. The first response is dismissal. It is a conspiracy theory. Stockpiling is obviously legal. Nobody is coming for my food storage. The second response is alarm. They're coming for our supplies. The laws are already in place. We need to act before the window closes. Both of these responses share a common foundation, which is a nearly complete absence of actual legal knowledge about what the regulatory framework governing private resource stockpiling actually contains, what it actually permits, what it actually restricts, and under what specific and narrow circumstances it can be applied to the activities of a private individual engaged in good faith emergency preparedness.
The truth, which is significantly more nuanced and significantly more interesting than either the dismissive or the alarmed response suggests, is that a genuine legal framework governing private stockpiling does exist in the United States and in most comparable developed nations, that this framework contains real restrictions and real enforcement mechanisms, that those restrictions are narrower and more specific than viral social media content implies, but broader and more consequential than the dismissive response acknowledges, and that understanding this framework precisely and completely is itself a critical preparedness skill. Legal vulnerability is a threat vector. Regulatory non-compliance is a risk factor. The seizure of improperly stored materials, the citation for zoning violations related to storage facilities, the liability exposure from improperly handled fuel or chemical storage, the food safety regulatory issues that can arise from certain commercial adjacent food preservation activities. These are real outcomes that have happened to real people engaged in what they believed was entirely lawful preparedness activity. Not because the law prohibits preparedness, it does not, but because the law governs the methods, the materials, the quantities, and the contexts of storage in ways that most preparedness practitioners have never examined with legal rigor, and the gap between what they are doing and what the law requires is a gap that closes around them in ways they did not anticipate and were not prepared for.
This examination is going to move through the actual legal landscape with the same analytical rigor that the physical and scientific dimensions of preparedness deserve, because the law is not an obstacle to preparedness. Understood correctly, it is a framework within which preparedness can be conducted safely, legally, and sustainably, without the legal exposure that comes from ignorance of the regulatory environment. We are going to examine the federal legal framework, the emergency powers statutes that generate the most anxiety in preparedness communities and that are most frequently mischaracterized in both directions. We are going to examine the state and local regulatory layers that are, in practice, far more likely to affect the average preparedness practitioner than any federal statute. We are going to look at the specific material categories: fuel, food, water, medications, ammunition, and agricultural supplies that are subject to their own distinct regulatory regimes with their own distinct compliance requirements. And we are going to build a complete legal compliance framework that allows a preparedness-minded household or small group to maximize their storage capacity, their supply depth, and their genuine resilience without creating the legal vulnerabilities that ignorance of the regulatory environment produces. The federal
federal legal framework begins, for most discussions of stockpiling legality, with the Defense Production Act. And it begins there because the Defense Production Act is the statute most frequently cited in viral content claiming that the federal government has the authority to seize private food and supply stockpiles. This citation is not entirely wrong, but it is so drastically incomplete as to be functionally misleading. And understanding what the Defense Production Act actually says, what its enforcement history actually shows, and what its practical implications for a private preparedness practitioner actually are, requires going into the statute itself rather than relying on summaries of summaries that have been filtered through multiple layers of advocacy and alarm. The Defense Production Act was originally enacted in 1950 in the context of the Korean War and has been amended numerous times since, most recently and most visibly during the COVID-19 pandemic, when it was invoked to address shortages of personal protective equipment and medical supplies. The Act grants the President broad authority to direct the allocation of materials and services necessary for national defense, and it includes provisions that authorize the government to prioritize certain contracts, to allocate scarce materials, and in extreme circumstances, to control the distribution of materials deemed essential to national security or public health.
The provisions that generate the most concern in preparedness communities are the allocation and hoarding provisions, which authorize the President to prohibit hoarding of designated scarce materials when the President finds that such hoarding has occurred or is likely to occur. The word hoarding in this statutory context is not a synonym for stockpiling, and this distinction is legally critical. The Defense Production Act's hoarding provisions have never been applied to private individuals engaged in household preparedness stockpiling. The enforcement history of these provisions, across more than 70 years of the statute's existence and across multiple invocations during various national emergencies, shows a consistent pattern of application to commercial actors, distributors, and resellers who were acquiring materials in large commercial quantities for the purpose of resale at inflated prices during shortage conditions. The statute's operative language refers to quantities beyond reasonable personal or household needs, and the regulatory interpretations of this language in the enforcement record consistently apply it in commercial contexts involving material quantities that are categorically different from household preparedness storage. A private individual storing a one-year food supply for their family is not engaged in the conduct that the Defense Production Act's hoarding provisions were designed to address, have ever been used to address, or could reasonably be interpreted to address under the statutory language as it exists and as it has been judicially interpreted.
This does not mean the Defense Production Act is irrelevant to preparedness planning. It means that its relevance operates at a different level than the seizure of household stockpiles narrative suggests. The Act's allocation authority is genuinely consequential for supply chain dynamics during declared emergencies because it can redirect commercial production and distribution in ways that affect what materials are available for purchase and at what price. Understanding the Defense Production Act as a supply chain variable rather than a direct threat to existing private stockpiles is the accurate framing, and it actually strengthens the case for building stockpiles before emergencies are declared, rather than responding to shortages after the Act's allocation mechanisms have begun reshaping the distribution landscape. The lesson of the Defense Production Act for the preparedness practitioner is not that their stockpile is at legal risk. It is that the window for building stockpiles may be narrower than they assume, because the commercial supply chain that feeds retail availability can be redirected away from consumer markets by emergency authority, and the time to acquire materials is before that redirection occurs, rather than after.
The second major federal statutory framework that generates preparedness community concern is the body of executive executive orders related to emergency resource management, a collection of authorities that are frequently mischaracterized as giving the federal government unlimited power to commandeer private resources, including food storage. The executive order most commonly cited in this context is Executive Order 13603, signed in 2012, which updated the National Defense Resources Preparedness framework, and which generated an enormous volume of alarmed commentary, suggesting that it authorized the government to seize private food supplies. A careful reading of the actual text of Executive Order 13603 reveals something substantially different from that characterization. The order delegates to various cabinet secretaries the authority to take actions necessary to ensure the availability of resources for national defense purposes, but it does so within the framework of existing statutory authority, primarily the Defense Production Act, rather than creating new independent seizure authority. The order's provisions relating to food and agriculture delegate authority to the Secretary of Agriculture to take actions related to food resources, food resource facilities, and the distribution of farm equipment and commercial fertilizer, with these authorities exercisable during a presidentially declared national emergency.
The critical legal point about Executive Order 13603 and its predecessors and successors in the National Defense Resources Preparedness framework is that these authorities are not self-executing and have not been executed against private household stockpiles in the decades since the underlying statutory framework was established. They represent contingency authorities that exist in law, but that have enforcement histories limited to extraordinary wartime and national security contexts involving commercial and industrial resources, not private household food storage. The legal principle of takings under the Fifth Amendment to the Constitution also constrains these authorities in ways that are rarely discussed in the viral content that circulates about executive order seizure powers. The Fifth Amendment's takings clause requires just compensation for private property taken for public use, which means that even in a scenario where emergency authority was invoked against private stockpiles, the constitutional framework requires compensation rather than outright confiscation without legal process. This does not make the prospect of emergency authority invocation irrelevant to preparedness planning, but it does mean that the legal framework is considerably more protective of private property rights than the most alarmed interpretations suggest.
Where the legal framework becomes immediately and practically relevant to the average preparedness practitioner is not at the federal level, but at the state and local level. And this is the dimension of stockpiling law that is most consistently overlooked in preparedness content, and that creates the most real, concrete legal exposure for people engaged in preparedness activities. State and local regulations govern zoning, fire safety, building codes, and health codes, and these regulatory frameworks intersect with preparedness storage activities in specific and enforceable ways that can result in citations, fines, required remediation, and, in some cases, mandatory removal of stored materials. These outcomes are not hypothetical. They are documented in building department records, fire marshal enforcement actions, and health department citations across jurisdictions throughout the United States. And they have occurred against people who were engaged in entirely good faith preparedness activities, but who were conducting those activities in ways that violated specific local regulatory requirements without being aware of those requirements.
The zoning dimension is the broadest and most variable regulatory layer affecting preparedness storage, because zoning law is entirely locally determined and varies enormously between jurisdictions. Residential zoning classifications, which govern the permitted uses of residentially zoned properties, typically include restrictions on the storage of commercial quantities of goods, the operation of commercial activities, and the construction of accessory structures beyond certain size thresholds. A preparedness practitioner who is building a dedicated storage structure on their residential property, who is storing quantities of food or supplies that a zoning officer could characterize as commercial in scale, or who is conducting food preservation regulation activities that could be classified as food processing under local health codes may be in violation of their local zoning regulations, regardless of the entirely personal and non-commercial nature of their preparedness intent. The intent is not the regulatory standard. The activity and its physical characteristics are the regulatory standard, and activities that look like commercial storage or food processing from a regulatory perspective are treated as such, regardless of the practitioner's purpose.
The fuel storage dimension of local regulation is particularly consequential and particularly well enforced because it sits at the intersection of fire safety regulation, environmental regulation, and zoning regulation, all of which have enforcement mechanisms and all of which impose specific requirements on the storage of flammable and combustible liquids. The International Fire Code, which has been adopted with local modifications by the majority of jurisdictions in the United States, establishes specific maximum quantities of flammable and combustible liquids that can be stored in various occupancy types without triggering additional regulatory requirements. For residential occupancies, the maximum aggregate quantity of Class 1 flammable liquids, which includes gasoline, that can be stored without a permit or special storage facility is typically 25 gallons under the base International Fire Code, with variations in locally adopted versions. Above that threshold, the regulatory requirements escalate significantly, potentially including requirements for approved storage cabinets, specific ventilation provisions, fire suppression systems, and, in some jurisdictions, storage facility permits that require inspection and ongoing compliance monitoring.
The practical implication of these fuel storage regulations for the preparedness practitioner who is building a significant fuel reserve is that the quantity of fuel they can legally store in a standard residential setting is substantially lower than many preparedness resources recommend, and exceeding that quantity without the required storage infrastructure and permits creates genuine legal exposure in jurisdictions with active fire code enforcement. This is not a theoretical risk. Fire marshal inspections of residential properties, which can be triggered by neighbor complaints, insurance inspections, or routine enforcement activities, have resulted in citations for fuel storage quantity violations against preparedness-oriented households whose storage quantities exceeded local regulatory thresholds. The appropriate response to this regulatory reality is not to abandon fuel storage as a preparedness strategy. It is to understand the specific thresholds that apply in your jurisdiction, to acquire and properly install approved storage infrastructure if your storage goals exceed those thresholds, to investigate the permit requirements that apply to larger storage quantities, and to conduct fuel storage activities in full compliance with the applicable regulatory framework rather than in ignorance of it.
The food storage regulatory dimension is less immediately enforceable in most jurisdictions than the fuel storage dimension, because residential food storage does not typically trigger the same fire safety and environmental concerns that fuel storage does, and health department jurisdiction over private household food storage is generally limited compared to its jurisdiction over commercial food operations. However, the boundary between private household food storage and commercial food operations is not always as clear as preparedness practitioners assume, and activities that cross that boundary, even without commercial intent, can trigger regulatory scrutiny that creates real legal complications. Home-based food preservation activities that involve canning, dehydrating, fermenting, or otherwise processing food in quantities that suggest commercial-scale production have been the subject of health department enforcement actions in jurisdictions where cottage food laws are narrow or where the scale of the operation exceeded the exemption thresholds in applicable cottage food regulations. The specific trigger is typically not the storage of commercially produced preserved food, which is universally legal in any quantity for personal use, but the production of home-preserved food in quantities or methods that bring the activity within the regulatory definition of food manufacturing or food processing. The distinction that most preparedness practitioners need to understand is between storage and production in the regulatory framework. Storing commercially produced food, regardless of quantity, is essentially unregulated at the household level in virtually every jurisdiction in the United States. Producing food at home in quantities that exceed the applicable cottage food exemption thresholds, or using production methods that fall outside the cottage food exemption categories, creates regulatory exposure that varies significantly by state and locality. Understanding the cottage food laws in your specific state, the quantity thresholds they establish, the food categories they cover and exclude, and the labeling and facility requirements they impose is a practical preparedness legal compliance task that most practitioners have never performed, and that would significantly clarify the legal boundaries of their food preservation activities.
The water storage dimension of the legal framework is the least regulated of the major preparedness storage categories for most residential practitioners, because the storage of potable water in containers on private property is generally unregulated by local ordinances and building codes up to quantities that would be extraordinary by any household preparedness standard. The regulatory complexities that do exist around water storage relate primarily to the collection of rainwater, which is subject to a patchwork of state laws that range from active encouragement through rebate programs to outright prohibition in certain western states where water rights law governs precipitation collection, and to the construction of water storage infrastructure, such as cisterns or underground storage tanks, which may trigger building permit requirements, setback regulations, and in some cases environmental permitting requirements, depending on the jurisdiction and the scale of the installation.